So good evening and welcome to this session of London International Disputes Week 2021, which of course we're holding virtually for the first time and possibly the last time, where the focus tonight will be on the trade and commodities sector. I'm Robert Parson, Head of Trade and Commodity Finance at Clyde Co, and we're delighted to be able to introduce to you this evening a hugely experienced panel of lawyers who can share their experience from their time in trading companies, trading associations, solicitors' practices, and the commercial bar. We'll be covering a range of topics which are on the radar of legal advisors across our sector. And you, the audience, are going to have the opportunity to have your say by answering some survey poll questions which are going to appear on your screen, and you'll have about 30 seconds to answer each of those as they come up, and also by asking some questions on the questions function which you'll see on the panel, which should have appeared in front of you, and we'll try and deal with those in a question and answer session at the end. But let me first welcome our panelists. Annabel Deering is a solicitor who's practiced in the trade and commodity field throughout her career, both in private practice and in senior roles with the trade and commodity financial sector, and also within major international independent oil traders. That was before taking on her current role as head of legal at international steel trader Stemcor in July last year. So welcome to you, Annabel. Simon Rainey QC will need no introduction to many of you. Simon is one of the best known and most highly acclaimed practitioners at the commercial bar, and a star performer among a galaxy of leading names at Quadrant Chambers. His name appears against some of the key decisions in commodities, shipping, international trade, and natural resources in the English courts. And he's also one of the most sought after advocates in international arbitration. So it's great to have you here, Simon. George Mingay is a partner in the International Trade and Commodities Group of law firm Pennington's Monch Cooper, where he specialises in international trade, marine and energy. And he's a regular practitioner in London's many trade and commercial arbitration centres, as well as the English courts, and he sits as a board member of the London-based Minor Metals Trade Association. So thank you for joining us, George. Last but not least, Jonathan Waters is General Counsel for International Soft Commodity Trade Association, GAFTA, the Grain and Feed Trade Association. Jonathan's a barrister and an arbitrator, and he's held senior in-house positions across a range of industries, including 11 years as Group Legal Director of the British Medical Association, before taking on his current role at GAFTA in 2014. And GAFTA's well-known standard contracts account for some 80% of all grain traded globally. And in an average year, Jonathan will correct me if I'm wrong, GAFTA's arbitration system sees in excess of 700 claims in arbitration running across its book. So welcome to you, Jonathan. I'm going to kick off with a question to you, Annabel. And we've seen, of course, extraordinary year, but particularly in the commodities sector, we're seeing now a steady rise in commodity prices since the final quarter of 2020 as we come out of the pandemic. And that's sparked talk of commodities entering a new super cycle, as well as a rise in both oil and base metal prices. Steel now finds itself priced at something around triple the 20-year average, at around $1,500 per ton, having bottomed out at about $460 per ton last year, amid the darkest days of the pandemic. So I'm interested to know what you see as driving that surge now, and what are the potential dangers ahead if and when the market sees a major correction to that surge.
Thanks, Robert, and thanks for inviting me to be on your panel. You're right, we are seeing a kind of commodities boom in prices. This has taken us all a little bit by surprise at the end of 2020, because of course there had been a complete standstill with COVID, but recovery was quicker than we thought, certainly on the demand side. And that kind of was because China came out of the lockdown probably quicker than some of the other regions. Then they were followed by Europe and the Americas. They kind of came in and out of lockdown. It led to a situation where basically production couldn't keep in step with demand. So to some extent, it's the fundamentals of supply and demand, in which there's more demand than a pent-up demand and not enough supply. And then what we're seeing is, of course, market sentiment as well, somewhat panic buying, people being willing to pay whatever just to be able to get hold of some steel. The price of containers kind of trebling as well. So we're seeing freight prices going through the roof as well. That, of course, leads to this sentiment of buyers being desperate to get whatever they can get and to transport it in any which way. Added to that, as you always get in these sort of commodity boom periods, you then have your financial speculators looking at commodities as a kind of inflation, almost a hedge to inflation. And you see them then putting a lot of cash into commodities as an asset class. That doesn't really help us because we then find ourselves having to manage our physical portfolios. And so as one of our senior traders described it to me, it's actually a bit of a headache. On the one hand, yes, lots of trading, good trading volumes. On the other hand, quite a lot to manage. And in particular, having to manage that our, for example, our suppliers don't start playing games. They can also hold supply back, of course. They can also see that they're going to get a much better price if they hold production back even more. They can also potentially start renegotiating prices. So this is where we start worrying about price reopeners. And then, if the price then readjusts, as you suggested it might do, we then start having worries about customers either failing to pay or, in the worst case scenario, going bust. So it's been a sort of, because the government stimulus packages have been kind of supporting trading, we're getting into a situation where we're not quite in step with the fundamentals.
So could be the ingredients for a perfect litigation storm ahead?
Yeah, we think that there could be a perfect storm in so many ways. Now, of course, what we're having to do is more careful risk management. So the kind of thing that normally I might raise a query to the trading desk and they'd tell me to get back in my box, for example. So something like we recently checked on the terms and conditions. And I reminded them that where we've got a battle of the forms and we send our terms in, if a customer tries to sneak their terms in, remember to reject them. We don't like using the word reject because it sounds too harsh, but remember that we don't want to be bound by customers' terms because inevitably those terms will allow them to cancel the contract and walk away. And I did have a couple of sheepish traders come to me the next day and say, we have actually been accepting customers' terms. And I said, we're going to have to be harsh, in an environment like this. I'm sorry, I'm sorry to be the bad guy, but you can blame legal, but we do have to be more careful than when we're in a stable price environment because we're seeing big swings. The other thing is, of course, on the financing side, we had literally just closed our borrowing base facility when we had to once again go to the banks and say, sorry, but we need to revise all our assumptions because the prices are so much higher. I mean, that's not a big problem because the banks are happy that we're doing well and that we're trading, but it shows you that it's affecting all parts of the business and it's affecting our ability to access finance as well.
No, that's very interesting. We'll probably come back to some of those themes a little later. Simon, I wanted to ask you probably a question that people are bandying around a lot at the moment, and it's this: what lasting change do you think it will be felt, for better or for worse, to court and arbitral procedure as a result of experiences we've all had and the changes in process we've all had to cope with during COVID? And do you think that'll make London a more attractive venue for trade and commodity disputes going forward?
Well, I think lasting changes there definitely will be, and I think almost certainly for the better, which will, I think, improve the attractiveness of London as an international arbitration centre. The running of arbitration and also the commercial court during the COVID-19 time has been, in my experience, overwhelmingly positive and has been highly illuminating and indeed educative. Because I think we've all learned, and I think we didn't really believe it in March last year when all this started, that virtual hearings really work. Whether you're cross-examining witnesses, a fact or expert, whether you're making legal submissions, they work. And so I think the lasting changes will be an increase in using virtual hearings to cut costs and the inconvenience of travel for parties. Another lasting change is a major familiarity with platforms like Zoom and Teams. I don't know what I think that the poll came in saying that everybody's more or less majority Zoom user, and I agree with that. It's a very easy platform. But do you remember the bad old days of cross-examining by video link, when everything seemed so clumsy and the line kept stopping and all that? All that's gone. We've discovered a completely new way of carrying out hearings, both either in small parts or the whole hearing. Another lasting change, I think, is going to be a possible long overdue departure of the bundles, this lot that sit behind me here. I mean, I think what we've really learnt how to use are electronic bundles. They were always used in the commercial court in heavy trials, and I think everybody's had to learn how to use them, either the sophisticated ones using a platform like Opus 2, or just having a PDF which you've got on your screen, which you scroll around and a reference is given to that. And again, I think a lot of people thought, well, I'm not sure I'm going to be able to use electronic bundles, but we are all using them. And a lot of the trade associations are having instructive seminars and training sessions to make them more widely used. There was a very successful one for the LMAA last week, was it, or the week before, when Opus 2 and the IDRC did a sort of teach-in and a shared pooling of views with LMA arbitrators who are already using it and have been using it for over a year. So I think that's another change. And then in terms of how we're going to be conducting hearings, well, there's a big debate at the moment. Will we go back to full-scale live hearings? Well, I think we will, certainly in the commercial court, because of the need for open justice. But in arbitration, I wonder whether we'll go back to quite the way we did it before. Take interlocutory hearings. Will we really all turn up for an hour's evening hearing or a 2 hours half-day hearing? Why not do it by Zoom? I think the one thing we will have to learn is possibly how to use hybrid hearings, because there are some disadvantages to all of us being in separate rooms, as we are tonight. Arbitrators can't sit together and discuss cases, which I think can be awkward. And when you're counsel presenting a case, and I've done so many cases virtually over the last year, I wouldn't have believed it possible, but you don't get the same interaction with the client and the solicitor. The passing of the post-its notes, the quick discussion over a cup of coffee in the transcribers break, and WhatsApp discussion groups aren't quite so good for that. But I think what's now developing, and another lasting change, is the use of hubs. So you have a counsel hub, respondent, counsel hub, claimant, where the clients and the solicitors and counsel are all in that particular hub. They're interacting by Zoom with the arbitrator hub, and witnesses are coming in from around the world. I did a long ICC arbitration in December where we had that, 5 little groups, and it worked fantastically well. So I think, yes, definitely lasting changes, definitely for the better. I think we've all been pleasantly surprised. I don't know what the last poll question was which came up, but I think we've all been pleasantly surprised, and I think it will enhance London as an efficient and more cost-effective arbitration centre.
Jonathan, your position as GC at GAFTA, how has GAFTA as an arbitral forum and its members adapted to particularly remote appeal hearings during the pandemic? Of course, first-year hearings are typically done at a distance anyway. But many practitioners, participants in arbitration are hailing the enforced use of virtual hearings as a major step forward in efficient case disposal, and we've obviously see what the reaction to the poll is on that. And presumably for some proceedings, such as the old sniff and see right terms arbitrations, the pandemic has thrown off a few logistical challenges, I would have thought. But how has it all worked out?
Thank you, Robert. Well, in terms of GAFTA, we have allowed limited virtual hearings, and we've amended our rules so that if the majority of board members are unable to travel, then the board has a discretion to hold a virtual hearing. In terms of how has that been received, it's been received extremely well, both by arbitrators and the trade generally. In addition to that, as a result of the pandemic, we've looked at other procedural improvements that we can make. For example, we now have electronic signatures. That, plus the use of virtual hearings, has resulted in far greater efficiency for arbitration, and on average, the time for a case from the opening to its conclusion has reduced by between 1 to 2 months. So there's been some very positive gains in terms of efficiencies. In terms of right terms, and for those who aren't aware, this is where a seller guarantees conditional arrival. Well, I'm actually pleased to say that the pandemic has had no effect, simply because I don't believe we've had a right term case for about 5 or 6 years.
I have to ask, George.
You did, yeah.
What's your experience and those of clients that you work with, being in terms of remote justice, whether it's that in the court or arbitration during the pandemic, and can you see an acceptance of some level of remote process, as Simon was suggesting before, perhaps hybrid, when those COVID restrictions cease, particularly as many law firms and other participants are now reimagining what full-time office work looks like, be that 2-3 days a week or however people are going to play it?
Yes, Robert, thank you, and thank you for inviting me this evening. It's a good question, and I agree very much with what Simon was saying on the point. Certainly, my impression of virtual hearings over the past year has been a very positive one, and certainly they have tended, particularly as time has gone on, to work more and more smoothly, with early teething problems generally being ironed out or anticipated. And certainly with the use of electronic bundles coming on enormously, along with the sorts of platforms that we use. I found from the clients a more mixed response, and that partly depends on where they sit within the sector, because of course we have all sorts of clients, some of whom are very international by nature and who have significant legal departments, and others across the spectrum who perhaps have less support and who are encountering the English dispute resolution system, arbitration, or the courts for the first time or on an irregular basis, and who have obviously missed the opportunity to join in person and to see the process of justice happening. And there really I think pick up on the points that Simon made in particular about certainly with the tribunal from the perspective of the client, where if it's necessary to break away to discuss points, usually that's needed to be done by way of a breakout room or some other means, and that can on occasion cause a slightly more disjointed start or sections of a hearing. And also, of course, although there are WhatsApp groups and all sorts of measures around this, the means by which you communicate with clients, counsel, and others. And so I agree entirely with Simon in relation to the future perhaps being in hybrid hearings. And we'll have to really see whether these changes and the success of them, where there have been successes, are embraced and consolidated upon. I think for me, just in closing, probably the biggest drawback I've noticed of the virtual hearings has been that opportunity to mix with the counterparties, and that's both at a client level for them to mix with their opponents who they haven't necessarily seen since the dispute may have first arisen, and of course for the solicitor, possibly less so the counsel teams, but for the solicitor teams to mix with their counterparties. And I know Jonathan, with his mediator hat on, would no doubt say, "Well, it's far too late to be thinking of settlement at the point of the hearing." But in reality, that is quite often the first time that the clients and the counterparties get together, and it's amazing what can sometimes happen before you get to the end of the hearing in terms of achieving a decent settlement for everybody.
So you want a virtual coffee machine room where you can inadvertently bump into the counterparts and discuss settlement during the adjournment.
I think we'd accept that. And what I had wanted to mention, of course, was hubs are, I'm sure, to be seen increasingly in the future, and there'll be teething problems with those. And we saw that best, I think, at the Oscars this year, where Anthony Hopkins got his leading actor Oscar, but hadn't decided to turn up at the hub in London in order to be broadcast to the awards in LA. So perhaps we'll have to grapple with those sorts of issues.
Thank you very much. Annabelle, I want to go back to a point you touched on a little bit earlier. You were talking about the finance gap that's growing up partly because of this price surge, but there's been a bigger trade finance gap that we've been seeing around for a while, which has always been part of that cocktail of ingredients that could lead to trouble ahead. And there's been a lot of discussion over the last few years about that steady withdrawal of the traditional finance banks from commodity and trade. The expectation was that alternative finance, with supply chain finance particularly, providing a significant proportion of that, would fill the gap. So what effect do you see either the Greensill collapse, which is still slightly not filling our TV screen so much these days, but also a possible fall in confidence of alternative financiers? We had all of those commodity failures in Singapore and elsewhere last year as well. What effect do you see that having on the market? And should we, is trade finance gap driven litigation something that we might be seeing as the world attempts to emerge from COVID?
Possibly. I think that, however, because of the high prices, it won't put people off. So I think that the banks like to dip their toes in and out of commodities. This is what I've seen several times in my career. They'll get scared, they'll exit commodities. We saw some quite high profile frauds last year in Asia. Some of the banks lost quite a lot of money and decided to just get out. It was too much trouble. But then they start to see some of the rewards that can be made from commodities. And of course, it's also seen as a very good diversifier for portfolios. So banks always kind of like to keep an eye on commodities. But of course, they've got their regulatory issues like the Basel IV capital adequacy type requirements. And they generally have to watch their reputation. So they take longer to make decisions. They have lots of credit committees, etc. So there was a space, and there still is a space for the alternative lenders. Now, there are different types of alternative lenders, of course, and Greensill was its own particular type. They're very different from, let's say, the commodity trading houses that we know and love. And so the Vitals and Trafigures, they are lending as well. They're lending from their own cash. And so they have lower cost of funds. They can do it very nimbly. They have quite straightforward procedures. They're very often interested in the offtake. So they're very close to the project and very interested in many cases in the project and have a great involvement in it. I think that the Greensill thing is a case unto itself, but I don't think it will put parties off lending to commodities. I think, however, that that companies that care about their reputation will obviously still want to stay with banks, and banks will want to stay with their customers. It's just getting harder and harder to try to keep banks happy. And that does mean that necessarily things take longer. We have more and more kind of compliance obligations to fulfill, more and more due diligence questionnaires. That is part and parcel of the world that we currently live in. And of course, COVID hasn't helped that. And certain other factors like the new climate change obligations won't make that life any easier on that sense either.
I'm very interested. I mean, we will come back to some of that a bit later as well. So, Simon, I just want to turn to you. We've all heard since early 2020 the rather overused phrase unprecedented. Everything's unprecedented these days in the context of COVID and how it's interrupted normal commercial, personal life, and much discussion over whether existing pre-COVID force majeure language, particularly, it caught the effects of COVID infection or COVID restrictions imposed by government to prevent it and contain it. We'll hear from Jonathan, I think, later about GAFTA force majeure clauses, but given English law's non-recognition of force majeure as a concept, the current fitness for purpose of drafting has obviously come under some scrutiny, and there hasn't been a big wave of decisions on this, but I think some have pointed to the line taken by the Supreme Court, for example, in FCA and Arch, as a pointer to where we might see the English court going with future cases. And some of the clauses in current contracts, of course, particularly long-term contracts, were drafted well before the pandemic and will still be in force beyond it. So what do you see as the likely issues that are going to arise under different wordings, and what are the drafting solutions? Putting you on the spot.
Well, that's certainly a big question. Well, yes, I mean, force majeure clauses started coming under scrutiny almost from January or February of last year, when things started going wrong for in the Chinese market with Chinese deliveries and the issue by the Chinese government of force majeure certificates. I think the problem with many force majeure clauses is that they've grown out of older clauses with bits and pieces bolted on, I think with the greatest respect, often without very much thought. I'm not talking about force majeure clauses that are drafted by specific drafting committees like GAFTA. I won't comment on the GAFTA clause, but like BIMCO and other bodies like that. I'm talking about the ones that just come up in ordinary trading contracts. When COVID-19 first hit last year, and performance of contractual obligations, shipping cargoes, receiving cargoes, transporting cargoes, didn't matter what it was, became either much more difficult or unprecedentedly involved, or impossible either permanently or temporarily, I think a lot of force majeure clauses simply weren't much good at all. They're good at dealing with a simple event or a single event, like an export prohibition or a Vale dam burst or something like that. But for an amorphous, swirling set of difficulties like COVID has been, with government regulations in one country, government guidance in another, a voluntary action in another, things became very difficult. I think there were, I mean, everybody will have had their own different problems in the cases they dealt with. I've dealt with a lot of force majeure in the last year, from every aspect, from trade right the way through to government procurement contracts. But I think there are three big problems that come up in my experience. The first problem is those force majeure clauses, the old-fashioned ones, which you still see an awful lot of, which simply have a long list of events, a ragbag of events, and nothing more. And I think the problem with those sort of clauses, which people found when people rushed to them and said force majeure, is you've got to find the right event to fit what was happening. Was it an epidemic? Did you mention epidemic in your force majeure clauses? A lot didn't. Was it government regulation? But was it government regulation, or was it just Boris saying, stay at home if we'd like you to? Was that within the event? So that was the first problem, those very specific old-fashioned clauses, without a sweep up at the end, which said, or any other event beyond the reasonable control of the parties, came a cropper, in my experience. The second big problem that came up was that a lot of clauses speak only about prevention. So if you are prevented from performing by whatever the list of things is. And many of the problems with COVID-19 then, in the middle, when things were cheering up, and now, again, when we went back into lockdown, and as we're now emerging, it's not that performance has become absolutely impossible, prevented. It's because performance has been made fantastically difficult, has been hindered or suspended, or has been made very involved or much more costly, etc., etc. And clauses that simply refer to prevented by don't help you, because provided there is one way round, take the frozen Chinese rabbits case in 1975, all supplies were intended to come from China of these rabbits. They weren't Chinese origin rabbits, just frozen rabbits. And the whole of the Chinese frozen rabbit market closed down. I think it was an epidemic. There were lots of other places to find frozen rabbits, and so however difficult it was, you had to try and find them. That was the second big problem. And the third big problem, I think, is causation. Was the epidemic the cause? You mentioned the FCA, Financial Conduct Authority, and Arch decision. I'll come back to that in just a sec. But if your clause says prevented by, then the current English case law, which I think ends with the decision of Mr. Justice Tier in the Seadrill Ghana case, 2018, is that the force majeure event has to be the sole effective cause. So if it's combining with other causes that are not within the force majeure clause, so you've got an epidemic is partly the cause, but other things are the cause, then bad luck. You can't rely upon your force majeure clause. In the insurance context, the position is different. FCA and Arch, the case you mentioned, there the Supreme Court took a much more holistic view with the but-for test in insurance law, and said that you can put certain events together to see what the overall sort of causative mix is. That's not possible as a matter of construction on the current case law. So I think in terms of drafting solutions, I've seen, and I've been involved in a number of measures with contracting parties, and I've seen it in forms that are now being brought in, or contracts that are now being negotiated in which I'm involved. First of all, I think COVID clauses are going to be a real fact of life. You can't rely upon a force majeure clause now, because we're no longer dealing with an event that's completely unforeseeable. It's here, it is foreseeable. It's going to be with us probably for 2 or 3 years, may never go away. Let's look on the bright side. But I think therefore, contracting parties are going to have to deal with that particular problem with COVID clauses, and I'm seeing a lot of that, especially European parties. They're completely on top of that. The second drafting change I think we're seeing, and if you're not seeing, we should definitely be considering, is widen your clause from prevented by to hindered by, or made more difficult by, made materially difficult by, suspended by. That's not a new development. There are plenty of old cases, First World War cases, where the clauses said hindered by, when exports or imports to Germany dried up, and you could find other sources, but hindrance was enough to let you out. You didn't need to, because it was too difficult. And then in terms of causation, some clauses are now being drafted which say caused by or materially contributed to by. And that gets you out of this sometimes very difficult hurdle of trying to establish that it was the sole effective cause when there were other things coming in, just the reluctance of workmen to go to the port, not because it was banned, but because they didn't want to take a risk of illness, so they stayed at home. Is that a force majeure event? Is that the epidemic or their voluntary decision? Get rid of the sole effective cause test in your drafting if you can. And then I think a big thing we've seen, because of simply the economic impact, which you can never deal with in a force majeure clause, the prices going up, market instability, performance being a completely different thing. How about having a material adverse change clause, which we've seen in other sectors in long-term contracts? The clever people in their long-term contracts had those already. I think some people have learned the hard way that might be a better way to go. And don't just think force majeure, it's at the back of the contract. When anything goes wrong, I'll look at it. So I think those are my impressions. I hope I haven't taken too long with them, but it was a big question.
I can hear people thumbing over to the FM page in their contracts
Absolutely,
right now to check.
So they should be.
But
George, I'm looking forward to hearing about the GAFTA clause.
Well, George, let me just ask you, as a practitioner in commodity arbitration, what have you seen in terms of increased attempts to invoke force majeure? When those phone calls come through, how many of them are runners, and how many of them are hopeless for the reasons that Simon's pointed out?
Well, certainly, I'm sure in common with many in the market, there was a huge increase in inquiries and in advice at the start of the pandemic. And given what had happened with SARS and what had happened with Ebola, and of course the pandemics do feature in these clauses in the generic broader sense as do epidemics, nonetheless it was obviously an event of a nature that caught a great many people by surprise. And I at the start anyway, in terms of many of the cases and inquiries I dealt with, there seemed to, from a top level perspective, there was a general willingness to negotiate around the edges outside of the contract to arrive at a sensible outcome where possible. And that's because, it's a global event. There were, absolutely, as Simon has said, local and government restrictions coming in left, right, and centre in the ports, with all sorts of impacts on shipping and on trade. And because of that, parties were tending to start from a position of trust in terms of a problem before them that they needed to grapple with. And so it was obviously important to ensure that on the open side, that all of the deadlines and everything else for producing evidence, if the clauses contain that, etc., were met properly. But there seemed to be quite a phenomenal success rate in achieving sensible outcomes. And I say that because you do from time to time encounter force majeure type defenses or arguments which are little more than the fig leaf in respect of significant price fluctuations, and which can take you down a rabbit hole in terms of the evidence required to successfully knock those back, depending of course on what the particular event is. So it was refreshing, if you like, looking for a positive, to have a real problem faced by a great many clients, and broadly speaking, a common interest in resolving those. Now, of course, there are always going to be some disputes, I suppose, are arising out of these clauses and out of events, and quite how those are ultimately determined will remain to be seen. I think there could well be more in the pipeline as well, for very many of the reasons that Simon has just said, in that now we're all properly on notice of this. We're not so much in the fast-moving environment of March, April 2020. We're a year further ahead. We know that that COVID-19 and related COVID-type viruses are likely to be a part of the landscape. And so it is certainly that opportunity to brush off the clauses and to make sure things are shipshape.
Well, don't throw away that supply of fig leaves just yet. You never know when they're going to come in handy. Jonathan, I mean, the COVID pandemic has obviously had lawyers like George and others, thumbing through the textbooks on frustration and reassessing FM provisions. But as GC of GAFTA, which obviously has its standard form contracts and its well-established clauses, are you seeing frustration increasingly argued as a defence for claims for non-performance, where the facts fall for reasons we've discussed, perhaps outside the FM clause? And I should say the GAFTA FM clause, many people take the view that it does actually cover a lot more than the old-fashioned ones. But please let me know what your view is from the hot seat.
Okay, a bit of context. As we said earlier, 80% of world trade in grains is based upon GAFTA standard form contracts, and we currently have over 80 standard form contracts. I'm summarising, but broadly our force majeure clause deals with either prevention of shipment or prevention of delivery. And the word prevention is really important for the reasons that Simon explained. We're not looking at delay, we're not looking at inconvenience. We're looking at prevention, which in itself is a high hurdle for any claimant to overcome. So under a GAFTA standard form contract, we define the events of force majeure. In a standard GAFTA contract, there will be 11 non-exhaustive examples of what may constitute force majeure. We don't refer to pandemic, for example. Instead, we have reference to act of God, and of course current case law is that something such as COVID-19 could well fall within the definition of act of God. But I always give a health warning to GAFTA members when it comes to force majeure. It's an incredibly difficult claim to bring. Not only have you got to show under the GAFTA contract that the event falls within the contractual definition, you've got to show that it prevents either delivery or shipment. And even then you've got to comply with the notices clause, which is a separate clause within the GAFTA contract. And a lot of parties tend to forget that very important notice provision. If you asked me, Robert, 12 months ago, would there be an increase in force majeure claims, I would have said, absolutely, I can see that. With the benefit of time now, I can say that we haven't experienced a rising trend. There's certainly been a lot of talk when I talk to members, when I talk to lawyers about possible FM claims, but we haven't seen the number that we were anticipating seeing. Do bear in mind that there's often a time gap between a dispute arising and a case being referred to GAFTA, but as of yet, I haven't seen that rising trend that I would have predicted 12 months ago. In relation to frustration, well, that's a legal concept that I think is very rarely, or was very rarely, visited in the context of commercial contracts, possibly until about 12 months ago. And I do see a trend, an increasing trend, to argue frustration in the alternative, albeit on most occasions not very successfully. But the argument tends to be on the basis of, well, we accept there's a force majeure clause, however, it doesn't cover absolutely everything that we thought it should cover. Therefore, we're going to argue in the alternative frustration. I think that's quite a difficult position to adopt. So I have seen, particularly over the last 3 months, more arguments for frustration than I've seen than the past 5 years, but they tend to be as an alternative to force majeure. In other words, if we don't win on force majeure, we'd like to argue frustration in the alternative, which, as I'm sure we all agree, is not a particularly good place to start with. So overall, we haven't seen the trend that we were perhaps expecting. I think it was rightly pointed out that in a force majeure situation, parties have been quite willing to negotiate and come to compromises rather than go straight to the contract and look at a provision they probably never thought existed until COVID-19 came around. We are seeing parties looking at material adverse changes clauses. We haven't got any plans for that at GAFTA at the moment, but we continue to keep our force majeure clause under review, and we will take stock of what's happening in the market and what's happening in the courts and arbitration to determine whether we need to make any changes.
Well, I'm going to stay with arbitration for the moment, because Simon, one of the issue of perceived arbitrator bias is one of those issues that for as long as I was ever involved with commercial arbitration, it was always dogged commercial arbitration, where arbitrators are chosen from a sort of peer group of existing market participants. And we'll hear from Jonathan from the GAFTA perspective as an arbitral body on how commercial conflict and perception of bias is managed in practice. However, we have seen some significant movement recently on this subject, and I'm thinking specifically, of course, of the Supreme Court's decision in Halliburton and Chubb last year, which of course arose from proceedings connected to the terrible events of the Deepwater Horizon disaster. And I'm hoping you can explain the significance of that decision and how it's likely to affect the conduct of arbitration in the international trade and commodity sphere, and of course beyond it.
Well, I'll certainly try, Robert. Thank you very much for that question. Yeah,
in
the
2
decision,
minutes.
In 2 minutes. No, thank you very much indeed. I'll wind myself up and go like a Duracell bunny. The decision of the Supreme Court in Halliburton and Chubb certainly made some waves, just so that people know what the facts were and what the case was about in 30 seconds. The issue in that case was that there were a number of insurance claims being made against a fixed set of insurers by different players in the Deepwater Horizon tragedy, Transocean, Halliburton, etc. The arbitrator, or one arbitrator, Ken Rogerson QC, accepted appointments in multiple arbitrations, always on behalf of the same insurer, Chubb. That was found out about by Halliburton, and Halliburton said that gave rise to a perception of bias, because he was either acting for Chubb or he was learning things in one arbitration he'd bring across to another. In broad terms, the Supreme Court held that where there were multiple appointments, that was something which bore on bias, on the perception of bias, and it should have been disclosed. They clarified that arbitrators are under a duty to disclose matters that may give rise to the perception of bias, and that's a strict duty. They held, however, in a controversial bit, which I don't have time to talk about tonight, that if you look at it at the time the challenge is made, by that time, with hindsight, you could see that there's nothing wrong with Ken Rogerson in any way, and there was no real actual bias or perception of bias, and so his appointment wasn't set aside, even though it was disclosable and he didn't disclose it. That's very controversial in the international arbitration zone at the moment. But note that in Halliburton and Chubb, GAFTA and the LAMA intervened as interested parties and made specific representations that in their arbitral world, I won't say little arbitral world because it's a big world, but in their arbitral world, multiple appointments were a fact of life and were accepted by the players in that world. And the Supreme Court endorsed that and said, well, where there's a custom and practice about multiple appointments, then it doesn't need to be disclosed. So lessons for the future. I think some people have read that as being a clean bill of health for trade arbitrations. We don't need to worry about anything again. Not so, I don't think. I think what has come out of the Supreme Court's decision is an enhancement of the duty of disclosure on arbitrators. The Supreme Court ducked the issue about whether an arbitrator has a duty to investigate before he makes a declaration. Should he actually interrogate himself to find out whether there are any past cases he's done or past things he's done? But although they didn't endorse it specifically, they certainly didn't say it was a bad thing or didn't represent English law. And the cases both before and after Halliburton have stressed that it's often the fact of not disclosing things, even things that when they are disclosed can be seen not really to matter very much or to give rise to the perception of bias, which themselves, the very fact of non-disclosing those things, can give rise to the perception of bias. Interesting decision of Mr. Justice Cockrell in a case called Tatneft before Halliburton. Very interesting decision about a football arbitration involving Newcastle United, if anyone supports that team, where Michael Beloff QC got himself into difficulties about non-disclosure, although again, it was held that didn't really matter at the end. So I think the lesson, I think, for trade associations and trade arbitrators is, if in doubt, disclose. And remember the advice in a very old trade case, a sugar case, 1976, Gill and Duffus, where Mr. Justice Moorbeek said, even experienced trade arbitrators should look very carefully at the circumstances of the case to see whether there were any past matters, which even if they don't think they matter, should be disclosed. Get it out. Being open and being transparent, I think, is really crucial for faith and confidence in international arbitration.
You might have picked up from the poll that actually it was interesting to see that one of the concerns people had was multiple appointments by the same party to an arbitrator, and which segues very neatly into the question I'm going to ask Jonathan. I'm going to ask you something actually which really interests me about GAFTA's name and shame defaulters list. But before I do, I just wonder if you could say what you think from hearing what Simon said there, and obviously, you know, GAFTA, along with all trade arbitrations, which are peer group arbitrator faculties, there's always that potential conflict to manage. And how do you, or do you get involved in that, and how is it policed, and how do you help and guide arbitrators into how they conduct themselves to avoid these sorts of issues?
Okay, I mean, first of all, as Simon said, GAFTA were an interested party in the litigation, and as we said on the front page of GAFTA News when the case was published, it's the result that GAFTA wanted. So, you know, we were quite happy with the result. The court, from our perspective, gave careful consideration to GAFTA's rules and procedures, and they acknowledged this common trade practice and the understanding within the trade that arbitrators may take on multiple appointments. That's not to say, of course, that we are complacent, and Simon touched upon that. In terms of GAFTA's rules and procedures, you know, we do have some quite extensive rules and procedures which sit behind our arbitration. We have a code of conduct, for example, for qualified arbitrators. We have a mechanism whereby if a party to a GAFTA arbitration feels that an arbitrator is possibly biased, then there is a mechanism for dealing with it, which involves a written complaint to GAFTA's Director General. If that's unresolved, we will establish a complaints committee formed of 3 members of GAFTA Council who will independently hear the complaints, for example, an allegation of bias, and make a determination. I also have to say in practice that when an allegation of bias is made against an arbitrator, most GAFTA arbitrators, by no means all, but most GAFTA arbitrators will simply stand down. They're not obliged to do so, and if, of course, they feel that there's no suggestion of bias, they don't have to. But in practice, most will often do so. So in terms of Halliburton and Chubb, we welcome the decision. In terms of appropriate policies and procedures, we believe that we have them, and we believe that our policies and procedures are robust. Do you want me to talk about naming and shaming, Robert, or is that for later?
Well, but I was intrigued because I looked at GAFTA's website the other day in the news section, and it had the name and shame list. This is for people who aren't aware of it. People who've defaulted arbitration awards or cost awards get named on GAFTA's website, or at least there's some detail visible to everyone. And then they also get named if they pay up eventually, just to show that the medicine works. And I was just going to ask you this question, Jonathan: how often does it work? That was really the question I was getting at.
Okay, well, very briefly, as you rightly say, if a party defaults on a GAFTA arbitration or fails to pay the fees, then they will be named and shamed. However, the list of companies that appear on the defaulters list is only available to GAFTA members. What we encourage GAFTA members to do when we deliver courses around the world is to look at the defaulters list as part of a due diligence counterparty risk procedure. And if the name of a potential counterparty appears on the list, then you ask yourself the question, do I really want to do business with them? In reality, the vast majority of defaulters are not GAFTA members. If a defaulter is a GAFTA member, then we deal with that through the defaulters mechanism, but also through an internal mechanism whereby we will suspend their membership and or ultimately terminate their membership if the default continues. We had 29 defaulters posted over the last calendar year. Is it effective? Yeah, it is. And we also have had challenges where a party believes that the naming and shaming has caused them damage, reputational damage, and have sought to bring proceedings against us, which I'm pleased to say we've defended comprehensively. So it does work. And I think if you're a GAFTA member, it's well worth just visiting that list. So if you're dealing with a new counterparty, ask yourself the question, are they on the list? If they are, do I really want to be doing business with them? They're on that list for a very good reason. They've defaulted on an award of arbitration, or they failed to pay the arbitrators or GAFTA's fees.
George, I'm going to ask you very quickly, because I've got a question I want to put to Annabelle on a particularly hot topic at the moment of climate change. But have you ever run a conflict of interest bias claim to try and set aside an arbitration or remove an arbitrator?
Not recently, certainly. I remember in very long ago days, another Michael Beloff case being relevant to something I was dealing with, although that related to an issue where he was sitting as arbitrator and a counsel for one of the parties was from the same set. That's probably more than 20 years ago, and obviously that's very well trodden ground in this jurisdiction. It's occasionally something you have to obviously help familiarize clients from other jurisdictions with, but that's all fairly readily explained these days.
Okay, well, thanks very much for that. Annabelle, one of the things that is very much uppermost in the minds, particularly in oil companies, we've seen a steady rise in both activist and regulatory-led climate change litigation over the last few years. And the election of the Biden administration really seems set to drive that forward further. I think most of the cases so far have been in the US, but there's an increasing number elsewhere as well. We've seen the impact here, as an aside to that, with the whole of the West Cumbrian mining furore, where the permission was reversed as a result of action. And I'm really interested to know whether you see a lot of potential for litigation in this area. It's interesting to see the poll question. People split pretty evenly between people who said it's never going to bother me, and some who are saying, yeah, well, it could be quite highly likely or moderately likely that I'll face it. But what do you, as a legal head in industry, do to address potential vulnerabilities? Because the idea, of course, is to avoid it altogether.
Yeah, I think you can. Well, I think that there's two things. I think the question is really, are we talking about the sort of thing that Jonathan was talking about, which is the kind of naming and shaming, and there will be a lot of that. There will definitely be a lot of sort of reputational type pressuring. And then there are the legal obligations. And so, I mean, STEMCOR being an intermediary will be less affected, for example. But if you're talking about a steel producing company, they're anyway subject to carbon targets under the well, it was the EU directive. It's now going to be the UK equivalent. But actually, I think that the question about these stakeholder activists is really, on what grounds are they challenging these projects? Because stakeholder activists are, of course, different from shareholder activists. Stakeholder activists are more like your Extinction Rebellion. They're people who shout loudly and have a view on things. So, for example, the West Cumbria mining example, we took an interest in that project. They were going to be potentially mining metallurgical coal in the northwest of England. And this is something that hasn't happened for quite a long time, of course, because we're shutting down fossil fuels in this country. The reason why this project was potentially different was that met coal produces coke, and that is still a major commodity that's used for the production of steel. And if we don't make it domestically, then we would be importing it FOB Australia. And so when you kind of calculate the emissions, it ends up being sort of net pretty much the same, with the difference being that this project was very, very sustainable in the way that it was being set up. So it was kind of one of the more progressive type of modern mines, but it got shot down. Partly it was a kind of argument between central government and local government. So the local Cumbria Council were told by central government, partly because of the optics of the thing, because they're going to be hosting the COP26 in Glasgow, and we're supposed to be showing that we have good climate change credentials. But actually, that's not the end of that story, because West Cumbria Mining intend to strike back. So they're actually taking the government, or at least they're taking Cumbria County Council to judicial review, is what the latest that I heard on that one. So it really depends what end of the telescope you look at it at. But I think that, yes, we will be seeing some types of litigation, but more, and it's going to be a little bit like you remember we had with the modern slavery, or we had with the gender pay gap. It's going to be kind of pressure to do the right thing, more sort of peer pressure. And of course, depending on your PR company, depending on your PR department, people can get around these soft obligations. If the government is really very serious about tackling climate change, and they start to make those obligations bite, and they start to impose penalties, and they start to enforce those penalties, and some parties feel that the law has been interpreted against them, then you might start to see some form of litigation. But I think at the moment, with the regulations being relatively loose, there isn't anything to litigate over yet, but that might come.
We've obviously got reports like Client Earth, Banking on Climate Change, lots of this name and shame. Do you think that people in government and prosecution authorities read this stuff and are under a bit of pressure to go and do something to answer the clamour?
Yeah, I think they've got a problem because the Tories, for example, have just won, for example, the Hartlepool by-election. They're torn internally because the other point about the West Cumbria mining was that it would have created a lot of jobs in that particular red wall area, and those would have been well-paid jobs. The argument also went that they were doing it in a very sustainable way, and so those would have been potentially industrial jobs that are part and parcel of this transition, because steel, of course, 250 tons of steel are needed for each wind turbine. So every single part of a wind turbine involves steel, from the foundations through to the blades, through to the generator. So that's the argument that they were making. But then I think, we're also seeing activists like the Good Law Project, the famous Jolyon Maugham, who took on Brexit. And so what you're seeing is more and more like Client Earth. These are more kind of celebrity protest pressure groups. They are a law firm, but they're funded by, Brian Eno and Pink Floyd and that sort of, they're funded by sort of celebrity pressure groups. And what they're going to be doing is nipping at the heels. They've been sort of going around the FTSE 100, checking on whether they're doing their environmental disclosures properly. And if they're not, they're kind of reporting them to the FCA. And they're more or less naming and shaming the government, saying, come on, government, you've set these targets, people are not keeping to them, or they're not disclosing their environmental targets properly. Why don't you do something about it? And curiously enough, some of the companies like Glencore, who were reviewed by Client Earth, got a bigger tick for engaging better with their environmental disclosure obligations than the likes of Centrica, who they deemed to be giving kind of wishy-washy, paying lip service, almost what they call greenwashing, essentially just going through the motions of making a disclosure, but not properly engaging. So that was a curious thing to see. And I think we'll definitely see more soft pressure. The question is, what are the government going to do about this sixth budget on climate change, which sets really, really steep targets for us to reduce emissions by something like 70% by 2035. And how are they going to do it, and who's going to pay for it? Those are going to be where you find that the questions bite. And crucially, on what assumptions are they basing these baselines? Because if you then have a downturn, an economic downturn, you find that actually your assumptions weren't correct anyway. We saw this with carbon trading.
Well, we've come to the end of our time. We've got a couple of questions from the audience, and actually one of them slightly follows on from the name and shame discussion I was having with Jonathan earlier, and I'm interested in the panelists' views. And the question is, do you think that other arbitral institutions should have a name and shame list of that type? I'm not talking about the Client Earth type, but the type that GAFTA does. And Simon, what are the dangers in that? We've heard from Jonathan that GAFTA have robustly fought back against anyone who's tried to challenge them for doing that. Do you see that catching on?
Well, I think it's something which is very much restricted to organisations of which people have to sign up and become members. I mean, for example, LMA arbitration, you're not a member of the LMA. I mean, I'm a supporting member, but that's the people who are sitting as arbitrators or supporting the organisation. A Greek ship owner, a Singaporean charterer, whatever it is, they just happen to contract by reference to LMA arbitration terms. So I don't think there's any possibility of naming and shaming unless you actually have to sign up to the rules of a club like GAFTA. International Cotton Association is even stricter. They've had a lot of challenges to their procedures, where they had to have very, very strict naming and shaming more draconian than GAFTA probably. But you've got to sign up to that. And that's why it only applies to members. If you sign up to interesting to hear that GAFTA was challenged. If you sign up to the club saying, if I don't pay, I get named and shamed, and then you turn around and say, I haven't paid, but it's very unfair to name and shame me. That seems a very unrealistic ground of challenge. But no, I don't see any future for it outside member organisations.
Well, I think we're going to have to wrap up at that. We've run over our time a little. I just want to thank each of today's panelists, Annabelle Deering, Simon Rainey, George Minge, Jonathan Waters. Thank you very much indeed for joining this session, and thank you, audience, for attending in high numbers and for your questions. Many thanks, and I'll look forward to seeing you all next year, possibly in person. Many thanks.